call. My name is Dr. William Puett. I'm Chair of the Hawaii Civil Rights Commission, and it is time for us to call the meeting to order, which is what we are doing at this very moment. The meeting is called to order. And so the first item of business on our agenda is the approval of the minutes of the November 7th, 2024 and November 19th, 2024 commission meetings. I would ask
I'm sorry. Did those get sent out? I was looking for stuff today and I didn't see who sent that out. Sorry.
so if they haven't been sent out, then we will have to postpone them until till the next meeting.
I
Marcus,
I think I sent them out quite a while ago, but they've also been
Okay.
posted on our website. So
Oh, is that the okay, sorry.
Okay, well, as long as they have been posted sufficiently in advance in order to meet the requirements of the Sunshine Law, what we might be able to do now is to have our host put them up one at a time, and we can make a quick look at them to see if they can be approved. So is that possible?
Yes.
Start with the oldest one first.
Yeah, I apologize, Marcus. I don't see anything from you.
it is possible that because it was so long ago, I didn't send them, but I did create them and they're on the website. Yes.
Okay.
So I
Okay.
apologize if I
Let's
didn't send
see.
them.
Okay.
November 7th. Draft
Could you post
minutes.
or share the November 7th?
Sure.
You can see them.
Then November 7th. Okay. I'll pull up the
Well, she can share them.
Okay.
quickly.
Yeah. Oh, where is my share button here? Oh, here. Can you see?
Coming up soon, hopefully. Yes, there they are.
Okay.
Okay. And if you would be kind enough to slowly scroll down so we can have a look at it.
Sure.
For those who have just newly arrived, we're having a quick look at the minutes for November 7th commission meeting, which were posted and sent out by the commission or by the executive director. But in case you hadn't had a chance to look at them, and you, especially the commissioners, Okay, so now that we've had a chance to sort of look at them, I appreciate the scrolling because it's a chance to read them again or remind us if we've had a chance to read them before. The question is, are there any corrections to the November 7th minutes? Hearing no corrections, the minutes November 7th are approved as circulated. Could you please put up the November, excuse me, which is
19.
yeah, November 19th.
Okay.
Hoping you can make that a little bigger.
Yeah, hold on. Getting there. Okay.
Very good. Okay, these are the November 19th. Again, please check them over as okay. So, are there any corrections to the minutes of November 19th? Hearing no corrections, the minutes of the November 19th meeting are approved as circulated. Thank you. And at this time on our agenda, uh, we will invite and as chair, I recognize our executive director, Marcus Kawadachi, to give his report.
Thank you very much. Good afternoon, everyone. Great to see you all today. I'm going to start sharing the first report I have, which is the mediation program year to date. If anyone cannot see that, please let me know right now. Okay. So the last report we had was a few months back in November. And first off, I guess I'll start by saying that this is one of the most important meetings that we have all year and probably one of the longest because we are going to be discussing a large number of bills. And so I will try to get through my reports as quickly as possible. But if anyone wants to have me slow down or ask questions, please feel free. So we have here the mediation program year-to-date report. As of the last reporting, we have had 16 additional cases go in the mediation process. And I'm sorry, not 16 additional, 16 total year-to-date. We've had 4 additional dispositions, meaning 3 settlements, as well as 1 case which did not result in a settlement. So year to date, we have 11 settlements versus 3 non-settlements, which is an excellent settlement rate of 78.6%. And the cases that we had, I'm going to go down here. Just going to go to the end here. One of them was settled through the Mediation Center of the Pacific, and 2 of them through the Hawaii Civil Rights Commission. And we are in a pretty good state as far as numbers of cases going into mediation, as well as those settling as compared to last year. So pleased with those results. Okay. Any questions before I move on? Great. So let's go on to the caseload report. And just want to check, are you seeing caseload report as of January 27th? Yes, thank you.
Yep.
Again, going through this relatively quickly. So we have currently 349 cases in our caseload. And the changes, I mean, there have been some closures throughout the entirety of our caseload. The case aging is relatively the same. I mean, we're looking at over 30% of cases which are 2 years old or older, which is of concern, and we always are trying to address that. There are some, I think, reasons why the past few months have been a bit slow with staff changes, as well as we're going through an office renovation, physical renovation now, for those who are not aware. So that's causing a little bit of disruption. So I think things will pick up once the renovations are complete. We'll be moving further down here. The big change to this report is that I've added on a whole fiscal year's worth of data at the very end on the right here. So once our annual report for the year is published, then we will add on the respective data. And so I'm not going to go through today and do much comparison, but you can see, for example, up here for pre-complaint questionnaires received, 579, which is, an increase from the previous 3 or 4 years. And so I think that's a reflection of the state of the people of the state, getting back to making inquiries and filing complaints. And so I think we're back up to essentially pre-pandemic levels there. And so, yeah, there's a lot of data here, which maybe at a later date would deserve a bit more delving into. But for the time being, I'm just going to leave it as that at that, and you folks can, maybe address questions later. And then the year-to-date numbers. So this column on the right is the most recent period of time we're looking at. But so from the beginning of the fiscal year, July 1st, through the present date, and taking that period and looking back, 5 years. So again, we're looking at a good number of pre-complaint questionnaires received from the public, a good number of intake decisions, a little bit lower on the complaints filed, a little bit lower on the investigations closed. But overall, I'd say the numbers are very consistent with what we would expect to see at this point. So that's my quick review of our caseload numbers. Happy to take any questions or comments if there are any. Okay. I'm not seeing any. So I'm going to stop sharing. Well, actually, I'm not going to stop sharing, but those are my 2 reports, Chair.
Okay, thank you, Marcus. So the next item on our agenda is the Chief Counsel's report. So
Yes.
at this time, I'm happy to recognize our Chief Counsel, Constance Yonashiro.
Right. So for anyone who's not aware, Connie is on maternity leave. And I would say that she is sad not to be here, but I'm sure she's happier where she is now with her new baby. And so, she is doing very well. So I'll take over with the Chief Counsel's report today and probably for the next few months. And so let's see. And I will say that having Connie gone has made me appreciate the great work that she does. So I apologize if some of the things are not as polished or organized as they normally would be. We're trying to fill the gaps until she returns. Okay, so update first on the docketed case. This is the Junko Knipe case. So a contested case hearing was held last month for 2 days. Well, yeah, last month, December 2nd and 3rd. And the hearings examiner was Judge Leslie Hayashi. And we understand that she will be filing her proposed decision, which would consist of findings of fact and conclusions of law. I would think somewhere in the near future. And once that is out, there's no particular rush for you folks to act on those findings. I mean, you can take your time, review them, but a Deputy Attorney General from the Labor Division will be assigned to advise you all, the commissioners, and will also review the hearing examiner's proposed decision, as well as the entire record. So that would be whatever has been filed in terms of pleadings, exhibits, etc. And that Deputy Attorney General will also write a memo to the commission recommending adoption of this decision or amendment or revision, whatever he or she thinks is appropriate, in order for you folks to come up with a final decision. And so that's a process which, first things first, we'll wait for the proposed findings of fact and conclusions of law to be issued, and we'll take it from there. So I know some of you have not been involved in this process before, and so you may have some questions, but again, I think we'll just take it step by step, and the first step would be to see the proposed findings. Okay. And let's see. The next item I have on the agenda for Chief Counsel's report is discussion on rulemaking. And I want to thank all of you commissioners for your hard work in I guess really the culmination of many months of work that were put into, getting our rules amended. And so, as you know, we did have the public hearing. We did meet after the public hearing, and you came out with your final recommendations. And so the step that still needed to be done was for Connie, Chief Counsel, to appear before the Small Business Regulatory Review Board, which occurred on January 16th. And she reported that that went well. They had a positive discussion. They had the board had some questions about the definition of employment, as well as reasonable accommodations for individuals with disabilities. And then they voted, and they did approve sending our proposed rules to the governor for signature. Okay, so it is definitely in progress. Just the other day, we sent the proposed rules along with the written approval from the Small Business Regulatory Review Board, and that is with I believe, the executive director of the Department of Labor and Industrial Relations, as well as the Attorney General. And so they're going to review, and then once it's all finalized, we'll send it over to the governor. So that is the report on rulemaking.
Okay, thank you.
Sure.
And unless there are any questions on this report, let's move on to our next item, which is the number 5 agenda, the
Yes.
the discussion on legislation, 2025 bills relating to civil rights, Senate bills marked SB, House bills marked HB, and then as you can see there, we have quite a lot of them. But my first question is, did we receive any written testimony that we should take up first?
No written testimony to be discussed now. We need to discuss the bills and then get commission positions on them. So
Right.
that's where we'll start.
Sure.
So we have 24 bills on our agenda to discuss today, and we have additional bills that have come in that we were not able to put on today's agenda that will need to be put on the agenda for the next meeting for discussion. So quite a few. And so I think, well, you all did receive a board packet. And the way that I would like to discuss the bills is in the order in which the bills on the bill packet appear.
Could you please
Just
share that document? I think that would be
oh,
helpful.
sure. Okay. can I share more than one thing? I mean, I can, let's see. Word packet. Let's- Hmm.
I can actually put that up on mine.
Yes,
From
it
this
is,
morning.
board packet was also posted on the website, and I could
Correct.
upload it and have it myself, but I think, to help everybody stay
Okay,
on the same page, as it were, it would be good if you could.
right. I think what I'll need to do is
Okay,
share
no,
the
here,
board packet. Oh,
here, I have it. Oh, let's see, where is the share? Can you guys see my thing? No.
um,
Where is the
I don't see anything yet.
share thing? Okay, hold on. What happened to my share button? Oh, here. Okay. Here we go. Can you see it? No?
Um, I can't see anything, but let me ask, if you share, can I also share at the same time?
I'm not sure,
Because I
actually.
think what needs to happen is I'm going to be sharing the actual text of the bills that we can
Right.
run through. So I
Wait,
think
maybe.
for the purposes of at least showing the board packet, let me try to share and see if that works. Okay. Right. So this is what was
Okay.
sent
Same one. Yeah.
as a board packet, and it's simply a listing of the bills categorized by type. So we have employment to start off with, giving a brief summary of the bills, and then a staff recommendation, initial staff recommendation at least. And so just for purposes of illustration, I'm going to scroll down. So we have the bills related to housing. We have the bills related to public accommodations, etc. Yeah, and I mentioned that I'm going to have to share back and forth because really this is just kind of a skeleton, just showing which bills we're discussing, the general summary. But I would like to take you through the actual text of the bills and then allow you folks to have a meaningful discussion. And I also will say that this is something that Connie Yonashiro created before she went on leave. And so it's not in a fully finalized form. To me, it's really just showing you the order in which we're discussing particular bills. Um, so, oh, and there's actually one more thing before we get started on the bills. Is the first agenda item under discussion of legislation is to grant authority for HCRC staff to give testimony consistent with positions already approved by commission vote on bills that are identical or substantially similar to previously introduced bills. So by that, in the past, we've had authority granted in this way to us, the commission staff, and that's because it's not always possible for us to have board action taken before we get notice of a hearing and then the hearing occurs. And so what we've done is that we've asked if the commissioners would allow staff, if a bill comes up, which is either identical to one we've testified on before, or almost identical, substantially identical, that we be allowed to give testimony that's consistent with what we have already provided. So that could be, earlier in the session, it could be, a previous session. And so that's the first item that I think we would want to, put to vote.
Agreed. So let's get to it then. On behalf of the commission, I move that the commission grant authority for HCRC staff to give testimony consistent with positions already approved by the commission's vote on bills that are identical or substantially similar to previously introduced bills. Okay, this does not require a second. So is there any debate?
I
Is-
think it makes sense.
Yeah, okay, good. Since there is no debate, is there any objection? Hearing no objection, this motion is adopted. Thank you very much, Executive Director. And can we begin now looking at the bills in the order that they are on our agenda? So the first would be Senate Bill 7.
Well, just to let you know, thank you, Chair. The order in which the board packet lists the bills is not the same as what's listed on the agenda. The agenda is listed in chronological order. Is it okay that we take it out of order?
Sure, but on this sheet, it says Senate Bill 7, and it also says that on the agenda, Senate Bill 7 relating to bullying.
Oh, well, yes, it starts off that way, but if you take a look, it'll diverge. Well,
Okay, I don't
it's
think,
a bit out of order is what I'm saying. Yeah.
let's just make it clear to everybody where we are so we can
Okay.
move along. And
Got
then,
it.
so let's start with Senate Bill 7.
Yes, good idea. Okay, so the summary, which y'all can read, but I'll read as well. So this is a bill relating to healthy workplaces. It prohibits any employer or employee from subjecting an employee to abusive conduct. It requires employers and certain employees to take all responsible, preventative, and responsive measures to ensure a safe work environment free of abusive conduct. It prohibits employers and certain employees from taking retaliatory actions against employees who engage in certain protected acts. It establishes a penalty, private cause of action, and remedies, and requires the Department of Labor and Industrial Relations to adopt rules. And this would be in a new part of Hawaii Revised Statutes, Section 378, which would likely not be within the HCRC's jurisdiction. And the staff recommendation here says to support intent/comments. Again, this was created prior to Connie going on leave. And so our staff has had a chance to discuss all these bills, and our actual position on this, I believe, or recommendation would be not to take a position. But let me share then the actual text of the bill. Okay. So as we go through, let me know if this is not working, but I think what I would do is just to, after reading the summary, hone in on, I think, what are the pertinent parts of the bills, particularly those that would relate to our mission. So if I can summarize, this is about healthy workplaces and talking about conduct that is somewhat similar to what we would call harassment, like legal harassment, but not concerning protected categories that are under our enforcement. So the language here says the legislature finds that if employees who have been subjected to abusive treatment at work cannot establish that the abusive behavior was motivated by race, color, sex, sexual orientation, national origin, age, or other category protected under existing employment discrimination laws, the targeted employee is unlikely to be legally protected against the abusive treatment. And so the legislature finds that legal protection from abusive work environments should not be limited to behavior grounded in protected class status. So I think that really gets to the heart of what this bill is. It's protecting abusive conduct, but not that which would be under our jurisdiction. And so it could be conduct that is, not sexual harassment, but harassment because someone's wearing a outfit that, people don't like. It could be anything like that. So for that reason, I think the staff's recommendation would be not to take a position because this clearly does not fall within our jurisdiction to enforce. It's actually clearly outside, by definition, what we would enforce. So that would be our recommendation.
Okay, so from a parliamentary perspective, if the recommendation is that we take no action, then no motion is required. Because
Okay.
motion would be required if we are going to support, or a motion would be required if we are going to oppose. But if we're not going to do anything, then no motion is required. Okay, so at this time, however, let us receive any of the remarks or comments from the commissioners, if there are any. Otherwise, we just get to move on to the next one. No motion is necessary. So I see Commissioner Joanne.
Yeah.
Evans.
I'm new, so my comment or question comes from being new. Certainly, have there been prior discussions when there is behavior that clearly we would not support, but it falls outside of the scope of the protected classes? Have we had discussion on this before? Because I don't think any of us individually would support bullying, particularly as defined in the bill. But has it been our position that if that's outside of our kuleana, we just don't take a position, as if we don't care what sort of behavior is exhibited in the workplace?
Well, I don't believe we've had a discussion on a bill like this in any way, shape, or form. So the question would be, and you can weigh in on this, whether or not we simply take no position, which means no vote one way or the other, or we take some kind of position, which could be the one that was in the first or the packet about supporting the intent. But I'm not sure if the rest of the bill then places such conduct in maybe you could help us with that, Marcus, by scrolling.
Sure.
down. Is the bill saying that the HCRC or they should file a complaint with the Civil Rights Commission as a result of this behavior, even though it may not refer to a protected class discrimination?
It does not, because the means of enforcing the law would be a private cause of action. I just passed it, I think. Let's see. Oops, where did it go?
So even if this bill is adopted, it wouldn't bring any complaints before the commission.
Yeah, correct. And I think that's understood by the introducers of this bill, that it's clearly separate from the types of complaints that would come under the Hawaii Civil Rights Commission's jurisdiction. Yeah, so it would be here, private cause of action. So a person who alleges a violation of this part may bring a civil action against the employer or employee in violation for appropriate injunctive relief or damages, or both.
And
Yeah.
would they be able to do that now without this bill?
I think the answer is there may be certain conduct that would fall under other causes of action, but probably most of those would not be covered. So this does create additional protections, I would say. Yeah.
And these protections.
Can we go back up to see what behaviors it is that they are objecting, or that they've outlined as being subject to this?
Sure. Here we go. So it's abusive conduct, right? And so the factors to be considered in determining whether conduct qualifies as abusive include, but are not limited to, the nature, frequency, and duration of the conduct, the context. So actually, maybe this is not what you're asking about, but this is very similar to how you would judge a harassment claim under our jurisdiction, in that it has to rise to a level of being severe or pervasive. And so I think this is sort of based upon that. These are the factors we would look at as well. So the nature, frequency, duration, the context. You know, whether there have been preventative and responsive measures taken by the employer, right? So I think these are all the things. And really the definition of what type of conduct is encompassed here. Let me see if I can find here. Okay. So abusive conduct means unwelcome, degrading, and dehumanizing conduct that is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. And skipping the next sentence, abusive conduct does not include petty slights, annoyances, and isolated incidents unless serious. And I guess I would reiterate going further up, what it is not is behavior motivated by race, color, sex, sexual orientation, national origin, age, etc. So not those categories that are protected by our existing employment discrimination laws.
But I do think that it says in the very beginning that they're expecting it to be severe enough that it shows up in physical symptoms, are they not? Severe anxiety, depression, suicidal tendencies, cardiovascular disease.
When I read this in whole, I don't think it's necessary for there to be physical symptoms, but the legislature is pointing out that severe enough conduct of this nature could result in physical consequences.
So, just my experience, because I've actually, in my former life as a faculty at UH West Oahu teaching labor studies, is that there were such actions brought not before the Civil Rights Commission when they didn't involve protected class, but before the OSHA or the Hawaii version that health and safety, because of some of those things you were just pointing out there, so that they may have cause of action under this other statute, which is not mentioned here. But so I guess what we want to decide now as a commission is what position are we going to take? So we have the choice that we take no position and then move
Right.
along to the next, or we have the choice of supporting with comments or with or without comments. So are you or any other commissioner suggesting, because I'm inclined otherwise, to stick with the recommendation coming from our staff that we take no position.
But I understand that the staff position was split. Is that correct? That the chief counsel recommended support with comments and the rest of the staff said, let's not take a position. Did I
Well,
misunderstand that?
I think what happened was that our chief counsel, well, we did not have a discussion with chief counsel because she went on leave prior to there being an opportunity for discussion. So this was what she had drafted as a document. So whether she ultimately would have recommended support intent with comments, I don't know.
Well, I guess I would invite the other commissioners to say how they feel, because to me, it's very, to me, the thing is, do we say, as long as you're not picking on our guys, we don't care what you do? Or do we want to take a position, hey, these aren't our guys, but we totally support the fact that you're going after behavior that that if you were picking on our people, we would react to that negatively, unless I'm completely off base. I'm just trying to say to the commission, where do we want to draw that line? Do we want to draw it narrowly? As long as you're not picking on our guys, we're not going to take a position? Or do we want to do it a little more broadly and say, we don't think that bullying, mobbing, harassment, and infliction of harm is a good, whether or not you are a member of a protected class?
Um,
Okay.
oh, sorry.
No, no. I didn't see a hand up or anything. Arsima, please.
I mean, I just don't think that I have enough of like, wouldn't that fall under some other jurisdiction or some other cause of action to be able to make a, take a position on it. So I am also inclined to not take a position.
Thank you.
Okay.
Commissioners?
Yeah, I hear the point. I just think once you venture outside of civil rights and you enter a whole new universe, and it's kind of difficult to tie workplace bullying to some of these mental health issues that are referred to in this bill. And not that it's not shouldn't be a concern, but it just really opens us up to this realm that is very broad and relatively vague.
Okay. So, John, did you want to weigh in on this? Do we lose him?
That was John.
I see John on the list of participants.
Yeah, that was John.
Oh, that was John. Okay, my bad. Yeah.
Yeah. No,
No, what I was thinking of. So, okay. Uh, so unless there's a motion that we support the intent of the bill, okay, which I don't see, then we take no action by default.
Okay, and my sense is that the other commissioners feel that it falls outside our purview and therefore we should take no position.
Okay.
Yeah.
So hearing no motion to the contrary, let's move along as a result of we're not taking a position.
Thank you. Next on the list here is SB 44 relating to housing discrimination. We've had bills like this before us in previous sessions, so this bill would allow the counties to prohibit discrimination against renters based on their source of income. Okay, and so this came up before in 2023 as well as 2024. And the testimony of the commission at that time was to support. And the comment here is this bill would allow the counties to be more expansive in protecting individuals seeking housing than what the state statute allows. And generally speaking, I think this is the trend around the country, and it is something that we as staff would support. And I will share the text. Okay. So this section is all about the general powers and limitation of the counties. The part that is being proposed to be amended, I'm going to scroll down. It's just one simple line here. Pardon me. Where is it? There, a couple lines. So this section says each county shall have the power to regulate the renting, subletting, and rental conditions of property for places of abode by ordinance. And so that's clear, that's what exists now. And what would be added would be including the power to prohibit discrimination against the renter based on the renter's source of income. Yeah, we've seen this before. I think it's pretty simple, and we strongly support this measure.
Okay, thank you. So the recommendation is just as support. If you prefer strongly support, would be acceptable. But that would be the question before us. Shall the commission strongly support House Bill, or excuse me, Senate Bill 44? Is
I'm
there any discussion?
curious, what kind of sources of income would be of concern?
Right.
Really what has been the most notable source of income would be governmental financial assistance, housing assistance. So, uh, rental assistance of various forms. And so we see that this may be a proxy for discrimination on other bases such as race, ancestry, disability, perhaps, if it's disability related rental assistance. And so, I noted that this is a trend that there was no source of income discrimination in housing in the nation, but state by state, I think we're seeing more states come on and add this to their state protections. Uh, sure, Joanne.
Okay, if that is the source, I wish it was more delineated to say that's what we're concerned about. Because that occurred to me. On one hand, it could be government sources, people saying, the landlord saying, well, gee, the only way they can afford it is because they're getting government assistance. But on the other hand, if you can't discriminate against wherever the source of income, you're talking about drug money and all sorts of organized crime cash that you can't discriminate against. So I'm concerned at the other end of the spectrum. On one end of the spectrum is the renter that you're trying to really help get housing, and at the other end is cash that comes from illegal sources. And do we take a position on that? Because I wouldn't think a landlord, as you know, if you take money from illegal sources, money can be revoked. So it puts the landlord in a very precarious position. So that's my feeling about that. I think the language is overly broad, saying it based on the renter source of income. That source of income is just simply overly broad unless it's defined somewhere else.
But if the landlord knows that their source of income, let's say, is from drug money, I think their problems are much bigger than being denied rental space. I don't know.
Or I guess actually, this is Heather McVeigh. Can you folks hear me? Hi.
Okay.
I can't
Hi.
see myself because we're sharing screen, but I guess also, so if it were drug money, the person might not have a source from an employer. So it might be kind of similar to someone that had a source of income that were, for example, a rental voucher or Social Security disability, for example. So anyways, just my 2 cents on that we've, seen it from vouchers as well as other sources that are identifiable yet not preferred. And sorry, Chair, if I spoke out of turn.
No, that's all right. And again, at this point also, people who are here who want to give oral testimony have the right to seek recognition. We just ask that you do that. So my question,
Chair, I do see a hand, by the way.
Oh, yes.
Our
thanks.
guest.
Based on Heather's comments, because that addresses, in fact, my own comments, should we support with amendments and then talk about things like the government assistance, rental assistance, or whatever, that this is what we're talking about, that this should be narrowed a little bit, and that is what we support. You shouldn't discriminate against a renter just because they're getting assistance from somebody. And that is narrower than source of income without any qualifications to me.
Okay, thank you, Commissioner Adams. The question basically that were before us is, shall we, according to the staff recommendation, support? All right, and if you want to, from listening to you, it sounds like you're speaking against that recommendation. But on the other hand, maybe you wish to just amend the comments. That's because we're not really prepared to offer specific amendments, right?
Okay.
But we have in the past said we support, and then added in the comments, with with amendments to, more narrowly, describe or preclude something like that,
I'll take
recommend-
that, I'll take that proposal. I like that proposal. Is that all right with Heather and Marcus?
Well, we operate at your pleasure. So I mean,
Okay.
whatever
Um,
the commissioners would like.
Yeah, I mean, this is an issue that seems very familiar to me, so we have our prior action that we took. I would be interested in knowing how we handled it previously.
Right.
If you're going to add an amendment, I mean,
Well, we're amending only, not the bill, but our recommendation.
I understand, yeah, if he was going to come back with a proposal to amend, how did we, or was it just a straight up? I don't
Well,
know.
Bill was suggesting support with comments.
Or with,
Yep.
yeah.
Uh,
Okay.
Arsima, and just FYI, so I do see our guest Patty Rougier has had her hand up, but in addressing Arsima's point, are you asking what our testimony was in the past?
Yes,
Okay, it was strictly to support, and I think part of the context is that source of income may be sort of a term of art that is broadly understood in the housing and
okay.
legal community,
Okay.
and so it also is part of a multi-year movement to add source of income to our housing protections. And I think incrementally there have been bills that have added certain protections. And so I clearly understand, Joanne, your point here. I think in the context of these bills being introduced, the source of income definition is a bit more well defined than I think what you're thinking. And
Okay,
so
that's fine.
it's I don't know, legal sources of income. We could maybe think of it that way.
Mhm.
But it is broad in the sense that it's not one particular type of government assistance, or it could be, alimony payments. It could be, I don't know, other types of things. Like if someone doesn't like where the person gets his or her money. So yeah, I think commissioners have supported in the past based upon that context.
Okay.
So, let us at this time recognize, Patty Rouget, who had her hand up and I missed it. Thank you. Patty?
Good afternoon. Thank you for letting me speak. I'm very nervous right now. I'm a Section 8 recipient. I'm disabled on Social Security. I'm also a victim of source of income discrimination, where I was forced from my previous apartment under unlawful reasons, but due to the court process, in order to save my Section 8 voucher, I had to find another apartment to rent in order to keep my voucher. I have learned through my research that there is no agency that enforces source of income discrimination in Hawaii. I have looked at other states like Massachusetts and California. They have actual agencies where one could file a complaint. That is where I have run into a roadblock in trying to get some form of justice for what happened to me. HUD does define source of income as Section 8 vouchers. But I think it also encompasses Social Security, supplemental security income, and other forms of public subsidy. That's what I wanted to say here today. I just happened to come across the fact that you were holding a meeting today and saw what was on the docket. I thank you all for allowing me to speak.
Well, you have
Thank
every right to speak, whether we want to allow it or not. But so don't be nervous. I would only just want to verify that your testimony is to support Senate Bill 44.
Absolutely.
I want to thank you so much. There's nothing like real life experience to help clarify the issues. So please feel that you've done a very good thing. It's helped clarify my thinking a lot.
Thank you very much.
So Marcus, if this, in a sense, protected class is added, would that then fall within our bailiwick as HCRC if that discrimination occurs? Would we end up hearing about those?
Yes, possibly. So what this would do is allow the counties to make their own decisions about including or not including additional protections for source of income discrimination. So if that were to happen, then yes, I mean, I think those cases very well could fall within our jurisdiction.
Okay.
In
So,
that case,
go ahead.
I go with the strongly support. I absolutely hear this person's frustration and I totally agree. The person doesn't have the funding. You try to give them government funding and then the landlord says, well, I don't like the fact that the government's helping you. That's missing the whole point. You see what I'm saying? So I think I'm all right. I've completely flopped that now that I've been clarified.
Very good. So is there any further debate, or especially anyone wishing to speak against the recommendation to strongly support? Not hearing any opposition in debate, the question is there any objection to having the recommendation of the Civil Rights Commission be to strongly support Senate Bill 44? And since there is no objection, that is that's the decision of the Civil Rights Commission to strongly support Senate Bill 44. Can
Thank
we
you.
move to the next one?
Yes. Moving on. Senate Bill 31. This is another housing related bill, so relating to property. It would allow a person who discovers a recorded discriminatory restrictive covenant to take certain actions without liability to invalidate the restrictive covenant. So this would be an amendment to Hawaii Revised Statutes 515, which does fall within our jurisdiction. I will share the text. Okay. So as stated, this section is currently within the jurisdiction of the HCRC. What this section, what the bill would do is amend to add a definition of discriminatory restrictive covenant. And so it takes a pretty traditional view of prohibitions. So it's a covenant which would violate the Federal Fair Housing Act. So that would be discrimination on the basis of race, color, sex, religion, familial status, disability, or national origin. Or else they're also talking about the Equal Protection Clause of the United States Constitution under the very important case of Shelley versus Kramer, which was a racially restrictive covenant in that instance. And so it would amend 515.2, and then would also amend 515.6, which already contains a prohibition against written instruments relating to real property. So in other words, a restricted covenant that forbids or restricts the conveyance, encumbrance, occupancy, or lease thereof to individuals because of, and this is the key part, race, sex, including gender identity or expression, sexual orientation, color, religion, marital status, familial status, ancestry, disability, age, or HIV. So I bring this up because we would as staff support this bill, but we think that it needs some clarification because this relates to several parts of this bill, but just illustrating, this definition talks about the prohibitions under the Federal Fair Housing Act, which are defined thus, race, color, sex, etc. But the law itself forbids more than that. So this is under our state protection. So race, sex, gender identity expression, sexual orientation. So there's things that are not covered under the federal law, which are covered under our state law. So the recommendation, I think, would be to support the bill, but to clarify the language, making sure that all of the state protections are encompassed, in the definition and in this latter part, which has some additional language. And just to understand what this bill does, which is quite interesting, I think, is that these covenants, discriminatory covenants, are already not enforceable. But what it does is that it reduces sort of the red tape when there is a restricted covenant that someone has in a property that they want to convey to someone else. And so this part here under D, it says, so any person who discovers a recorded discriminatory restrictive covenant may, essentially what it says is if the parties agree that it's not enforceable, then they just have to kind of put a document in there that says it's unenforceable, and that will be recognized. So they don't have to go through, I guess, more formal means to, invalidate the restrictive covenant and convey the property. So if that's, I'm not sure I made myself clear, but that is sort of, after several readings of this, I think that's the summary that I have.
Okay, thank you. So the question is, shall the Civil Rights Commission support with the comments just now outlined by the Executive Director of Senate Bill 31? Is there any debate?
I do a lot of deed work. I think it'll shorten a lot of deeds.
I think
Because they're
that's
always
the idea.
huge, a lot of language about, the discrimination that's in there or to the extent and all that kind of stuff. So if it makes deeds simpler, it's even a better benefit.
Mhm.
So I would agree.
Okay.
If you're seeking a second, I will second.
Yeah, all of these are coming as staff recommendations. I don't believe a second is necessary in the
Okay.
in the commission. So I stated the question already, and the question is, shall the Hawaii Civil Rights Commission support the Senate Bill 31 with the comments as outlined by the executive director? And so we've had one person speak in support. Is there any further debate? Or commentary by anybody who is here? Okay, hearing none, then is there any objection from the commissioners to taking the position to support Senate Bill 31? Hearing no objection, the Hawaii Civil Rights Commission takes a position to support Senate Bill 31 as outlined in the board packet, and to allow the staff to work on the comments that were already described or explained by the executive director. All All right,
Thank you, Commissioners.
next one.
Okay, so we're getting into bills related to public accommodations, where revised statutes 489. First one is Senate Bill 59, algorithmic discrimination. And I know our chair has opined on this topic in the past, and so this is a bill that we have testified on in previous years. What this bill does is prohibits users of algorithmic decision making from utilizing algorithmic eligibility determinations in a discriminatory manner. It would require users of algorithmic decision making to send corresponding notices to individuals whose personal information is used. It would also require users of algorithmic decision making to submit annual reports to the Department of the Attorney General. It also provides a means of civil enforcement. And so you can see the staff recommendation here is to support. The commissioners did support a similar bill in 2024. And I think generally speaking, we would view this under the realm of access to places of public accommodation, and whatever we can do to cut down on discrimination in such access is something that we would report, and we would support, that is. Yes, so let me move to the text of the bill. I mean, I don't know if we need to go in depth because it is somewhat lengthy. But that's the gist of it, and it talks a lot about what algorithmic decision making is, and so forth. So in any event, we would support this bill.
Thank you, Marcus. So the question is, shall the Hawaii Civil Rights Commission support the Senate Bill 59 prohibiting users of algorithmic decision making, excuse me, from utilizing algorithmic eligibility determinations? So that's the question, and it's now open to debate. And I'd like to take advantage of this opportunity, as has already been mentioned, that I strongly support the bill, and I'm just wondering if this would include what is now the word of the day, AI, because it strikes me that it would.
Right. I think it certainly would. I'm not sure I can easily scroll through and find where that would be, but in reading the bill, it did strike me that yes, AI is the specter that kind of covers all of this. So yes.
Thank you. All right, is there any other debate on the question to support Senate Bill 59?
Just question, Marcus, is it like, what's the difference between this and the prior one, or is it the same? Or do you know? The other one was not passed?
Oh, the other one was not passed, correct?
Okay.
Yeah. Sorry.
Okay.
That was, yes, that's the answer.
Any further questions or debate? Hearing none, is there any objection to this Hawaii Civil Rights Commission taking the position to support Senate Bill 59?
Just a question, is it support or strongly support? Because you had initially said strongly support.
Well, I had said my position. So,
All right, then I would like to adopt that as the commission.
then
I
it'd
don't
be
know how that
strongly
messes up your parliamentary stuff.
No,
but-
sorry. So is there any objection? Let's reword the question to the Hawaii Civil Rights Commission taking the position to strongly support Senate Bill 59. Hearing no objection, the motion to strongly support Senate Bill 59 is adopted.
very good. Next, we have Senate Bill 149 relating to discrimination in public accommodations. This is an interesting one, and this is a bill on which a similar bill was introduced last year. And so this has to do with really kind of redefining what a public accommodation is. So it establishes that it is an unlawful discriminatory practice for public accommodations to deny a person with a disability the full and equal enjoyment of information related to their services, facilities, privileges, advantages, or accommodations using information and communication technology intended for use by the general public as applicants, participants, customers, clients, or visitors. So the key part of that would be using information and communication technology. So we're expanding what, or the bill would expand what in the past we have interpreted as requiring a physical space, a physical location, to include, I would say, both information that is on a website that's related to a physical place of a public accommodation, but it could also be that site itself on its own. I had some additional comments. Well, let me just go to the text of the bill here. Okay. So, let's see. Right. So this is our good old section 489. Oh, that's not it. Okay, so what this bill would do is to, what did I just do? Okay, it would amend section 489-2 Hawaii Revised Statutes, which is our section encompassing places of public accommodation and the definitions, within. So it would be adding language about information and communication technology. So electronic information, software systems, equipment, using the creation, manipulation, storage, display, or transmission of data, including internet systems, websites, software, video, multimedia, et cetera, et cetera. Okay, so software applications, websites. And so the amendment to the definition of place of public accommodation would be, so I'll take you through. So traditionally, we've had this for many years. A place of public accommodation means a business, accommodation, refreshment, entertainment, recreation, or transportation facility of any kind whose goods, services, facilities, privileges, advantages, or accommodations are extended, offered, sold, or otherwise made available to the general public. Okay, so that's the public accommodation part of the definition. Goods, services offered to the public. But here the bill would add, regardless of whether the presence of the business, accommodation, refreshment, entertainment, recreation, or transportation facility in the state is physical or digital. So we are in the matrix, and everything, including digital things, are considered places of public accommodation if this bill passes. And that would really change the way that we view our public accommodation coverage. And so there's additional changes here. Let's see. So it would require that beginning July 1st, 2026, a place of public accommodation shall ensure that information and communication technology used to communicate with applicants, participants, customers, and other members of the public is accessible for full and equal use by persons with disabilities. I think we fully, strongly support that. And that communications and interactions through information and communication technology with applicants, participants, customers, and other members of the public with disabilities are as effective as communications and interactions with individuals without disabilities. And there's some guidance here about how a website might meet accessibility standards. Also a note about the undue burden standard. So if compliance would impose an undue burden on the public accommodation or fundamentally alter the nature of the public accommodations information and communication technology, which is language that is pretty universal when talking about, weighing requirements for whomever to fall under our anti-discrimination laws. Okay, so all that being said, it is somewhat scary, but I think our staff recommendation would be in the spirit of allowing the public as much access to places of public accommodation as possible. We would support this measure.
Okay. So, thank you, Marcus. And then the question before us then is to, following the staff recommendation, support Senate Bill 149 with comments. And then the comments are the ifs that you just mentioned.
Is it with comments? I mean, it
Oh,
does say that.
Marcus,
Yes.
if I could jump in, this is Heather McVeigh again. I think one thing that we had noted that might be worth sharing is that it looks like they are giving a full year for this law to be implemented. Because I do think, it's a consideration to allow people to catch up with technology. So, perhaps based on how well the bill is doing through the process, maybe we could offer that it would be given a longer lead time if that's where a sticking point was in any of the committees. So I think that was the note that we had in our discussion. Thank you.
Well, the comment you were suggesting then, it would be that it go into effect earlier.
Or later if necessary, because I think maybe the concern people would have is that a year might not be enough time to get the word out about the bill and allow for people to, get up to speed with technology, although, we would probably disagree, but, just to move the bill forward if that were a concern. Just a thought, I guess it's just a comment that we had in our discussion, but maybe not necessarily any change in language we should suggest.
Okay. So as far as staff is concerned, then, is it fair to say that you're recommending that the HCRC support Senate Bill 149 with, and then just that much and not,
Yes.
okay. Then let that be the question. And is there any debate?
I can see where there might be opposition to this bill. And it might be even considered anti-business, but I like it. And I support.
Okay, is there any further debate? Very well, then, is there any objection to the Hawaii Civil Rights Commission adoption of, or excuse me, recommendation to support Senate Bill 149? And hearing no objection, then Hawaii Civil Rights Commission adopts the recommendation of the staff to support Senate Bill 149.
Thank you. Moving along, the next category of bills relates to those that impact the commission or relate to civil rights in general. The first being, this is, I think I translated wrong. This is SB 55. It says SBSS, but it's SB
Really sorry
55.
to interject this at this point, but Accidentally, I seem to have lost my sharing
Oh,
when my cursor fell on the meeting thing on Zoom. So is there a way to get back the,
um,
I don't know if anybody else is having that problem, but I obviously somehow shut down what was being shared, and I don't know how to
okay.
get it back again.
Let me see if I can do anything on this end. I'll stop sharing and then share once again. Did that work?
Yes, yes, it's
Oh,
back. So
great.
the rest of the commissioners and anyone else who's here, if this happens to you, then I think please remark as such so that we can get it back, because it's important that you see these documents that are being shared.
Okay.
My bad. So the next we're looking at then is Senate bill.
Yeah, Senate Bill 55 relating to administrative rules. Um, this is pretty straightforward. So it would require all state agencies adopting, amending, or repealing a rule to make the full text of the rules of the agency available on the website of the Office of the Lieutenant Governor in a digitally accessible and searchable format. So again, I think in the spirit of increasing access of the public to services that we offer, I mean, or just information, our staff would recommend support. And I will share the text, although I don't think there's much to look at here. Oops, what
So
is going on?
again, again, I apologize for interjecting, but it looks to me like what you were just sharing didn't say 55, it said SS.
Yes, I think there was some translation snafu, so it is 55 instead of SS. Yes, correct. So let's see. Yeah, I mean, this is just adding a line here that the full text of the agency's proposed rules shall be in a digitally accessible and searchable format.
Okay, and the recommendation is to support?
Correct.
So the question then is, shall the Hawaii Civil Rights Commission, pursuant to the recommendation of staff, support Senate Bill 55 relating to administrative rules? Is there any debate? Hearing no debate, is there any objection to the motion that the Hawaii Civil Rights Commission support Senate Bill 55? Hearing no objection, then that is the recommendation of the Hawaii Civil Rights Commission to support Senate Bill 55.
All right. Thank you. The next bill we have is Senate Bill 47 relating to state holidays. We have, I believe, two bills that relate to holidays.
Mhm.
The first one here is Lunar New Year. So it would designate the day of the second new moon after the winter solstice of each year as the Lunar New Year. So it would be a new state holiday. And that's essentially the text of the bill, but I'll share it as well. Oops, not that. Um, right. So I mean there is some I guess preamble about why the Lunar New Year is significant, particularly in this state. And so in the interest of celebrating diversity and you know, just different cultures, our staff would recommend support of this bill.
Right, Jack.
Okay, so thank you. The question then is, shall the Hawaii Civil Rights Commission support is Senate Bill 47? I see Commissioner Adams.
Yeah, not surprisingly. Um, I think both of the holiday bills, if we are not going to take a position on harassment in the workplace, I don't think we should take a position on holidays. That falls outside our purview. I understand the appreciation for diversity of culture, but I just think having already talked about the one, which I think is much closer to what we're about, the whether or not we make a holiday is outside our purview. So I just think we should not take a position.
Okay. Is there any further debate?
Does this have to do with Chinese New Year's?
Yeah, Lunar New Year is the Chinese New Year's.
Oh, okay.
Tomorrow, right?
Oh, yeah.
Yeah.
But it does pertain to the civil rights staff, right? So there's a connection there in terms of having,
Because they get the holiday.
yeah.
Okay, so John, are you speaking for or against this recommendation?
Oh, I don't know. I mean, I like holidays. I think, but again, it's kind of a loose connection.
Looks like we're gonna have to vote on this one. Arsima, do you have a position?
I don't really have a strong feeling either way. But if that's why Joanne says, I'm okay with not taking a position.
Okay. So, the question is on supporting Senate Bill 47, and if you vote for it, then you're voting for that support. If you vote against it, then we're taking no position. So,
Chair,
yes,
if I may interject, maybe this would help. There is another bill that is with another, it's Hawaiian Independence Recognition Day, I believe is it. Let me see if I got that
Laku o
correct.
Ko'a in November.
Hawaii Independence Day. So I think as staff, we typically every year are faced with a number of bills relating to new holidays that are proposed. And so I think our position was sort of, okay, we can't really recommend one over another as long as it's sort of a legitimate, understandable, significant holiday. And so our position as staff would be to support both of these. And so I can understand sort of an all or nothing position as well, which I think is Commissioner Adams is expressing. So the other thing is, as staff, I don't think we strongly have an opinion one way or the other, except that we have nothing bad to say about Lunar New Year or Hawaiian Independence Day.
hey, well, if the vote is not unanimous to support, which is the vote, then we have to record the votes of each commissioner separately in the minutes. So bear that in mind. All right. Is there any further debate? All right. So it looks like there is objection. So therefore, we need to go through the commissioners list and do the voting. So when your name is called, please indicate whether you're voting for or against support of this Senate bill, right? 47. So let's start. So I'm going to go with Arsima first. Are you voting for or against supporting?
Against.
Okay. So, John, are you voting for or against?
I vote for.
Okay. And Joanne, are you voting for?
Against.
Or against? Against. Okay. So, if I were to vote for, it would still fail because 2 and 2 is a tie. So I'm going to vote for this one, and yet the recommendation will will not be adopted, which means our position is no position.
All right. Thank you. Oops. That's not right. Next we have Senate Bill 116. This is relating to discriminatory reporting. It would establish provisions relating to civil remedies for discriminatory reporting of a person to a law enforcement officer. So more specifically, any person who contacts a law enforcement officer to contact a person on the basis of the person's actual or perceived race, color, ancestry, ethnicity, national origin, place of birth, sex, age, religion, disability, sexual orientation, or gender identity, with the specific intent to infringe upon the person's rights. I'll add on here, it would be subject to a civil action. Okay, so the remedy would be civil action. And it would require the Department of Law Enforcement, in consultation with the Hawaii Civil Rights Commission, to provide guidance to the public on the enactment of this act. We had some vigorous debate about this particular bill. I think one thing that has happened since is there was a hearing held and it did pass, and the Department of Law Enforcement did testify in support of this bill. So as a note state here, the HCRC has supported similar bills in the past, back in 2021. And ultimately, our position as staff would be to support this bill. And as stated, it would put a burden upon our office specifically to provide guidance to Department of Law Enforcement. Let me share the screen here. How do I get rid of this thing? Okay. So yeah, I skip down to the bottom, very bottom, which outlines what our involvement would be here. Again, Department of Law Enforcement, in consultation with the Hawaii Civil Rights Commission, shall provide guidance to the public on the civil liability and remedies available for discriminatory reporting to a law enforcement officer pursuant to this act. So is it clear what's being covered here? I mean, it's I think based upon history or recent history, where members of the public have called the police to basically harass someone because of their race or other category, and why they report it on the news.
So can I ask, what is Karen bill? Because that's it's a staff recommendation / discussion, Karen, in quotes, bill, and then after that it says support.
That's sort of a shorthand where that's nowhere found within the text of the bill, but I think in popular reporting, it has such bills have been referred to as Karen bills, and I know some wonderful Karens, but I guess Karen is a name stereotypically given to someone who complains about things, and maybe in this case in an actually discriminatory manner. That's just sort of a shorthand, I would say.
All right, so we can ignore it when it comes
Okay.
to the recommendation of staff, which is to support the bill. So the question is, shall the Hawaii Civil Rights Commission support Senate Bill 116? Is there any debate?
I would hate to be named Karen, but
Yeah.
I've seen the videos and I support the recommendation.
All right. Is there any further debate? Hearing no further debate, is there any objection to the Civil Rights Commission supporting, and we'll just use the word, to Senate Bill 116 relating to discriminatory reporting. Again, hearing no objection, the Hawaii Civil Rights Commission supports Senate Bill 116.
All right, thank you. Moving on to Senate Bill 117 relating to defamation. Okay, this is one that we did support, and I'll relate our support from last year. So this is a bill that protects individuals who make claims of sexual misconduct from defamation lawsuits, unless those claims were proven to be made with malice. Okay, so it gets into definitions. So anyone who is alleged to have been subjected to sexual harassment, sexual assault, etc., and subsequently they are sued for defamation. So they wouldn't be liable for that reporting unless the claims were proven to be made with malice. So intentionally, recklessly, whatever the standard for malice is, I'm not sure. So what we did last year is the commission did support this bill, which is, I think, almost identical. But in the original form, there was some language that we had some disagreement with that we thought needed clarification. And so we did, the commission did offer support with comments, and those comments were to change the language. And that happened. So as the bill progressed, the language was changed. So what we have now is the bill in its most recent form with that changed language based upon our testimony. So that's where we stand now. The bill did not pass, but it is in its, I guess, better form in our opinion. And so I will share. And we do say support here, but I mean, I think it would be strong support, really. I'm not sure what difference that strong language makes, but yeah. So anyway, this is what's added here. So definition in cases of sexual assault, sexual harassment, and sexual discrimination. Again, the person would be, it wouldn't be liable for making such a claim unless it was shown to be with malice. Yeah.
Okay, so thank you. So the question is then, shall the Hawaii Civil Rights Commission strongly support Senate Bill 117 relating to defamation? Is there any debate?
This is one where I know I'll just go down as a no vote. I'm very strongly against this whole bill. Sexual misconduct, as those who are attorneys know, defamation per se includes 4 areas that if you make an untrue statement, it is automatically presumed to be damaging. And one of those 4 is sexual misconduct. And I feel strongly, particularly in this age where we don't seem to care very much anymore whether accusations are true or false, we just go ahead and make them anyway, that to make it easier for a person to defame someone is not the path that I can support. If anything, I think we should make it more difficult. We should make it easier to sue for defamation, because we've just gotten to the point where we just say all sorts of things and as if there's no impact, when the common law has made it very clear that there are at least 4 areas that are so explosive that if you make comments in any of those areas, damages, it's just presumed that it's defamatory. So I probably will be a voice of one, but I feel extremely strongly about this one. We've got too many people talking about too many people's sex lives, accusing this person and that person of pedophilia all up and down the spectrum. And I think I want to take a stand strongly for the truth. If it's true, it's a defense. I mean, you can only say it's true, you can only accuse someone of sexual misconduct if it is true. If it is not true, that becomes a defense. And I think we can't make it easier for people to make allegations in areas of sexual misconduct. And I also say this based on my experience. I have worked for a number of years now for a woman who is a forensic psychologist and also handles divorce cases. And the number of times where I have seen, or she has come to the conclusion that children have been coached by adults is shocking. Or it is falsely alleged in a divorce suit because a person wants sole custody of the children. So this idea of sexual misconduct has been weaponized. I know that's a popular term, but it has been weaponized. And I do not think we should make it easier for people to defame. You can tell I'm excited about it.
Indeed, we appreciate your passion.
Thank
So,
you.
is there any further debate? Since this looks like something that is going to be recorded vote, I'd invite and ask the commissioners to respond or speak in debate. So if we can ask Arsima.
What are you asking me? Sorry.
So I'm asking you, do you feel that, what's your position on this? Because Commissioner Adams,
So is the question supporting the staff recommendation, or what is the question?
right.
Yeah,
Well, the staff recommendation is to
staff
support. So the question is, shall Senate HCRC support Senate Bill
Yes.
7? And you believe that it's a good thing and therefore
Yes.
you think we should. Okay. So how about John?
Well, I was kind of ready to go with the flow, but after Joanne's comments, I'm kind of, I'm whether you're up for Secretary of Defense or Supreme Court Justice, I'm just kind of, disgusted by these notions being dismissed, and so I would say no.
Okay. And Joanne is saying no.
Yeah.
So then unless there's any further debate, and that means my vote has to be recorded, and I'm going to go with right now Joanne and John and vote against support. Now that means we take no position, right? So that's
Right.
3 of us against the staff recommendation to support. So there it is.
Thank you.
Moving along.
Sure. Senate Bill 170 relating to internet privacy. This is proposing to amend the Hawaii State Constitution by establishing the right of each person to own and have an exclusive property right in the data they generate on the internet. Well, I think we were a bit mystified as to why this bill was referred to us. I don't think it has anything to do with our jurisdiction or purview. So our recommendation would be to simply track. So take no position. I can show you the text of the bill here. Pretty simple, really. I mean, this is it. It would be amending the Constitution to allow the right to own one's own data generated on a public network information system such as the internet. Not really our area at all.
All right, thank you. So the question is still whether or not we're going to take a position or vote against taking a position on Senate Bill 170 relating to internet privacy. So is there any debate about this, or are you prepared to all vote against taking a position?
Sorry, I thought that for bills that we were just tracking, didn't we say that we didn't need to do anything? Like, cause I remember a whole bunch of bills from the
Yes,
last
okay,
round. Oh, we said we weren't.
all right,
'Cause
but I
otherwise
want to
we have another 15 and I have a hard stop in 10 minutes.
oh, I'm sorry. Okay, so, well,
Uh,
the only
yeah.
reason I'm putting it up to debate is some of you may want to move to support, right? So uh, it is the staff recommendation that we just track. However, that doesn't mean the commission has to follow that recommendation. And if there is any commissioner who wishes at this time to move support, uh, that would be your choice. But if you don't do that, then that's it. Then we move along.
Yeah, I was just referring to, I think when we were under the prior chair, I think there was something along that lines, but I mean, that's, unless you guys are gonna go through all the rest of these by,
Well, I'm only asking, is there any commissioner who wishes to move that we actually support this? And if there isn't, then we move along. And so having asked that and having received no response, then uh, we are following the staff recommendation just to track it. Can we move to the next bill?
Of course. The next one is Senate Bill 404 relating to service animals. We had some vigorous debate about this one. It requires sellers or providers of emotional support animals or of certificates, identifications, tags, vests, leashes, and harnesses that identify an animal as an emotional support animal to provide certain disclaimers to the buyer or recipient. And it establishes penalties for, I guess, violation of this law. And ultimately, staff, correct me if I'm wrong, I believe our recommendation would be to oppose this bill. And let me pull it up here. Okay, so this is making some distinctions between emotional support animals and service animals. So it is both businesses or persons that sell animals for use as an emotional support animal, and also for the selling of certificates, identification tags, vests, leashes, or harnesses that would identify an animal as an emotional support animal. So what this bill is saying is that because we're talking about emotional support animals, these are not service animals that would have a different sort of requirements. And so it would be required for a seller to provide written notice to the buyer or recipient of the animal, saying that the animal does not have the special training required to qualify as a service animal. The user of the animal is not entitled to the rights and privileges accorded by law to the user of a service animal, and also that knowingly misrepresenting as a service animal any animal that does not meet the requirements of a service animal would be a violation of the law. And likewise, with the items like leashes and harnesses, that item will not entitle the user to the rights and privileges accorded to user of a service animal. And knowingly misrepresenting an animal as a service animal would also be a violation. So staff recommendation would be, I think first of all, this is not really a problem that we're aware that even exists. I mean, an animal that is sold to another person could be any type of animal, and you don't really sell an animal as an emotional support animal. It becomes an emotional support animal because the person needs it for that purpose. And there's also already a law in the books that would make it a violation of the law to misrepresent a service animal as an emotional support animal, and we think that efficient or effectively covers situations such as these. So, we just don't think that this is necessary, and we would oppose.
Okay, so the question is, shall the Hawaii Civil Rights Commission uh, oppose Senate Bill 404 relating to service animals? Is there any debate? Hearing no debate, is there any objection to the Hawaii Civil Rights Commission opposing Senate Bill 404 relating to service animals? Since there is no opposition, the Hawaii Civil Rights Commission opposes Senate Bill 404.
Okay, thank you. We have another bill relating to service animals, which is Senate Bill 387. In summary, this would require the Department of Agriculture to be responsible for all neighbor island inspection permit fees. Let me just explain it in a better way. So there are these permit fees for service animals to arrive at airports around the state, except on Oahu, that fee is waived. So this bill would be to sort of provide equality to those traveling to all the islands. So instead of the person with the animal being responsible for those permit fees for service animals, that is, that would be covered by Department of Agriculture. And so that would, I guess, provide more fairness in travel. And again, in the interest of equality, as well as not feeling that those persons that need service animals should be burdened anymore, our staff would be in support of this measure.
Thank you.
I can pull that up here. Okay.
So the
So
question,
I don't have anything to add. This is just the text. Yeah.
sure. So the question is, shall the Hawaii Civil Rights Commission support Senate Bill 387 relating to service animals? Is there any debate? Hearing no debate, is there any objection to the Civil Rights Commission supporting Senate Bill 387 relating to service animals? And since there is no objection, the Hawaii Civil Rights Commission supports Senate Bill 387.
Great. Thank you very much. The next bill we have is Senate Bill 527 relating to education. This would establish and appropriate funds for 5 full-time equivalent positions within the Civil Rights Compliance branch of the Department of Education. The recommendation here says track, but in our discussion, we reviewed the bill in detail. Our recommendation would be to support. We recognize that this is money that is not ours to, decide what to do with. However, with the Department of Education, the more people devoted to civil rights compliance, we think the better. And that touches many different aspects of education. So our staff would be in support.
Very good. So the question is, shall the Hawaii Civil Rights Commission support Senate Bill 527 relating to education? Is there any debate?
Just one quick comment. I think I like the reasoning of the staff in this bill, but to me, it points out why we should have supported the first bill. We like the intent of the bill. So I will support this bill.
Okay. Is there any further debate? Since there is no further debate, is there any objection to the motion for the Hawaii Civil Rights Commission to support Senate Bill 527 relating to education? Since there is no objection, that motion is adopted, and the Hawaii Civil Rights Commission supports Senate Bill 527.
All right, thank you. Okay, we have a series of bills now relating to immigration, and I think this may be sort of for you as commissioners to figure out what kind of stand we want to take on these. And so there's HB 22 relating to immigration collaboration with the federal government. There is HB 440 related to immigration, and that has to do with covered educational entities and the Hawaii Health Systems Corporation facilities. There's also HB 457, rights of people in law enforcement custody before an interview with ICE regarding immigration matters. And then skipping over to SB 571, another bill relating to custody when someone is in the custody of ICE. So just, I guess, I'll put in the context that we've been going back and forth about the level of support, if any, to offer these bills. I mean, they are not within our enforcement jurisdiction, I think clearly. But this has to do with what level of support our commission thinks that the state government should give the federal government in its, I guess, recent immigration policies and actions. So I suppose we can go bill by bill. So this first one would allow state and county law enforcement agencies to collaborate with the federal government for immigration purposes in only limited specific circumstances. And I mean, I know that begs what those circumstances are. So let's see. These are a bit dense and complex. So
Well, perhaps another question is, Arsima, you indicated that you have a hard stop coming.
Yes, I was just writing in the group chat. I
So-
yeah, I have a call at 4 I have to jump on, so.
Perhaps it might be appropriate for us to adjourn and take up these remaining ones in our next meeting, which is
Yeah.
scheduled. So,
I have to get to it 4, so.
yeah.
Okay.
Okay, so that means if we still had 3, we could still move, but if John and Arsima are
Mm.
leaving, then that's the end of that. We must adjourn at this point and then have the remainder of the bills that we haven't been able to address postponed until our next meeting. All right, so I'm assuming there's no objection to that.
No.
Motion for adjournment, because otherwise we don't have anything else we can do. All right. So be it. It's 4 o'clock. This meeting is adjourned and the unfinished bills, plus apparently new ones that have come in, will be taken up at our next meeting.
Great.
all right. Thank you all.
When is our next meeting?
Weeks, isn't it?
I'm trying to remember. It was written down someplace. The 30th?
Uh,
No, I thought it was single digit February.
yeah, next Tuesday. So it would be, what is it, the 4th?
Yeah.
4th.
Yeah.
Yeah, February 4th.
February 4th. So be it.
Okay. Thank you all very much.
Thank you.
Mahalo. Meeting is adjourned. So Sandy, you're gonna stop the recording? Because I'm planning on signing out.